Welcome to the third night of our Notre Dame Vita Institute 2020 webinar series. I'm Petra Farrell, and I'm the Culture of Life Program Manager for the Nicola Center for Ethics and Culture here at the University of Notre Dame, and we're delighted that you can join us. The mission of the Nicola Center for Ethics and Culture is to share the richness of the Catholic moral and intellectual tradition through teaching, research, and public engagement, both on campus at Notre Dame and as Notre Dame in the wider public square. The Vita Institute is our flagship offering of our Culture of Life programming, and we are pleased to have you join us for this week's presentations. This webinar series will provide you with a small taste of our week-long Vita Institute intellectual formation program that each summer since 2010 has brought pro-life leaders from around the world to the campus of Notre Dame to study the fundamentals of the life issues with world-renowned scholars across a wide range of disciplines, including social science, biology, philosophy, theology, law, communication, and counseling. Our full Vita Institute program includes more than 20 presentations covering the full spectrum of topics essential to building a culture of life, including such important issues as racial inequality, disability, adoption, euthanasia and assisted suicide, public health policy, integral human development, and more. In this week's condensed series of presentations, we have been highlighting issues surrounding the beginning of life, and tomorrow we will begin to widen our conversation to address the equal human dignity that we all share. So let's go ahead and continue this exciting week of learning and conversation together. Tonight's speaker is the director of the Nicola Center for Ethics and Culture, Carter Snead. Carter is professor of law and concurrent professor of political science here at the University of Notre Dame. He is one of the world's leading experts on public bioethics, the governance of science, medicine, and biotechnology in the name of ethical goods. He is the author of What It Means to Be Human, The Case for the Body in Public Bioethics, forthcoming from Harvard University Press. Additionally, he has written more than 50 journal articles, book chapters, essays, and commentaries. He is also the editor of 2 book series for the University of Notre Dame Press, Catholic Ideas for a Secular World, and Notre Dame Studies in Bioethics and Medical Ethics. In addition to his scholarship and teaching, he has provided advice on the legal and public policy dimensions of bioethical questions to officials in all 3 branches of the U.S. government and in several intergovernmental fora. Prior to joining the law faculty at Notre Dame, Snead served as general counsel to the President's Council on Bioethics, chaired by Dr. Leon R. Cass. He has testified in the U.S. House of Representatives, the Texas State House and Senate, and regularly serves as an expert witness on bioethical matters before federal courts. Professor Snead also led the U.S. government delegation to UNESCO and served as its chief negotiator for the Universal Declaration on Bioethics and Human Rights. He served as the U.S. government's permanent observer to the Council of Europe's Steering Committee on Bioethics, and in 2008, he was appointed by the Director General of UNESCO to a 4-year term on the International Bioethics Committee. He is a member of the Pontifical Academy for Life, the principal bioethics advisory body to Pope Francis, and an elected fellow of the Hastings Center, the oldest independent bioethics research institute in the world. Without further ado, I am delighted to present Professor Carter Snead speaking on U.S. abortion law and policy.
Thank you very much, Petra, for that wonderful introduction. So we heard on the first day of our Vita Institute this week about the philosophical dimensions of the debate and the questions of what we owe to one another. And we learned that the only coherent moral and ethical approach to extending moral concern and the protection of the law is to include everyone, every human being, every member of the human family in the circle of protection and concern. And then we learned yesterday that the life of the human organism begins at fertilization. So in short, over the past 2 days, we've learned that the most coherent and richest ethical tradition, moral approach is to extend moral concern and the protection of the law to all human beings from conception to natural death. Tonight, my charge is to discuss with you the current legal landscape for American abortion jurisprudence. And what you're going to notice is that it's quite different and diverges quite a bit from the ethical norms and principles that we've been discussing over the past 2 days. It's important to grasp what the jurisprudence of abortion entails for a variety of reasons. Obviously, the purpose of the Vita Institute is to educate and provide intellectual formation to its participants. And in fact, the actual law, even stating accurately, descriptively what the law of abortion is in the United States, is something that a lot of folks can't do, including very sophisticated commentators, people in the press, including some scholars of the law, routinely misstate what the law of abortion is in the United States. And my goal for this evening is primarily to explain in some granular detail what the law is, and in appreciating what the law is, you won't be able to avoid the conclusion that our current regime here in the United States is maximally permissive with respect to the question of abortion, and moreover involves some pretty difficult inferences about the meaning of our Constitution. So it doesn't just extend to the moral questions we've been discussing, but there are actually important questions about the rule of law and the faithfulness to interpreting the Constitution, and even the role of judges that are implicated by the current question of abortion in the United States. So in order to trying to advance the slide here, it's not working. Just one second. There we go. In order to understand the law of abortion in the United States, it's primarily a matter of mastering the substance of 6 seminal U.S. Supreme Court cases. The law of abortion in the United States is, in fact, a creature of U.S. Supreme Court jurisprudence, beginning with the very famous case Roe v. Wade in 1973 and continuing most recently into 2016 in a case called Whole Woman's Health versus Hellerstadt. So in those cases, the Supreme Court essentially sets the outer boundaries of what states and the political branches are permitted to do to extend any legal protection to the unborn child, or to even regulate the manner of abortion, the way in which it's performed, who performs it, when it can be performed, and related questions. So that's a fundamental reality of abortion jurisprudence in the United States, is it's not really a matter of the political branches. It is instead a creature of the work of unelected justices on the U.S. Supreme Court, who are ostensibly interpreting the Constitution itself. So in order to understand abortion law in America and to understand how it stands in relation to the laws around the world and how permissive it is, and really how extreme it is, it's necessary to go through in some detail these particular cases. And so what I plan to do in my remarks this evening is to focus on these 6 cases, beginning with Roe v. Wade and concluding with Whole Women's Health versus Hellerstadt. The first case that we're going to discuss, obviously, is Roe versus Wade. And despite how famous it is, despite how everyone knows, has heard the name of the case Roe v. Wade, it is little understood in public discourse. And people frequently misstate the holding of Roe v. Wade. In fact, some public surveys show that people think that Roe v. Wade is the case that desegregated public schools. They don't understand even that it relates to abortion. But even those folks who rightly understand that it connects to abortion fail to understand what precisely the holding is, and as I said moments ago, how extreme it is, how it ties the hands of the political branches, both of the federal government as well as the various state governments, in what they can do to recognize, protect both the unborn child and her mother, as the case may be. So let's begin. We're going to move systematically through these cases with Roe v. Wade in 1973. Now, the case Roe in 1973 began evaluating a Texas state statute that banned abortions except in cases where continued pregnancy posed a threat to the life of the mother. Now, in this way, the law in Texas very closely approximated the law in most states in 1973. The case was announced, the decision was announced in January of 1973, and up until the announcement of the case, most states banned abortion, had a default rule of banning abortion. Some made exceptions for things like rape and incest. They all made exceptions for the life of the mother. Some had exceptions for serious health conditions that the mother was suffering from that would warrant an abortion in the judgment of her physicians. I think the number was 36 states basically banned abortion outright with some of those kinds of exceptions. There are only 4 states in the United States that presumptively permitted abortion up to a particular gestational stage, after which it banned abortion and subject to certain kinds of exceptions. So the baseline was quite restrictive laws on abortion in the United States before Roe v. Wade was announced. And the court, it's interesting, and this is a little bit in the weeds, but I think it's also important to understand this, that the case in Roe v. Wade began in the federal trial courts, as most federal cases do. The case began in the federal trial courts pursuant to a federal statute. It was heard by 3 federal trial judges. Normally, it's just 1 trial judge that hears federal claims. But in this case, it was heard by 3 federal trial judges who disposed of the case. It was brought by multiple parties, including Jane Roe. We later learned her identity as Norma McCorvey. But there were other parties as well who brought claims trying to get the Texas state law banning abortion invalidated. And these 3 federal trial judges did not hold a hearing. They didn't have any evidentiary hearing at all. They disposed of the question as a matter of law. They declared the state law to be unconstitutional by virtue of the 9th Amendment to the Constitution, which, I'm paraphrasing, reserves the rights to the people that are not explicitly set forth and stated in the Constitution itself. That it is a kind of catch-all reservation of rights to the people. It was largely thought to be a kind of inert part of the Constitution, part of the Bill of Rights until 1965. I'll talk a little bit more about that in a concurring opinion in Griswold versus Connecticut, the famous case involving the law banning the use of contraception by married couples, which in some ways laid the jurisprudential foundation for Roe v. Wade and the jurisprudence of abortion. But these 3 trial judges heard the case just as a matter of law and said the 9th Amendment prevents Texas from banning abortion as it does. But then they said, but we're not going to strike the law down. We're actually going to abstain from striking the law down pursuant to a line of cases in which federal courts frequently withhold themselves from interfering in state criminal law matters. Okay, so but by operation of this federal statute, the case was appealed directly to the Supreme Court. The statute has since been repealed. The statute that had 3-judge panels hear these kinds of cases. They appealed directly to the U.S. Supreme Court, and that was the procedural posture that the Supreme Court received the case. And why is that important? That's important because most of the time when there are factual disputes, most of the time when there are factual claims made, in this case about biology or history or even sociology, assertions that play a role in Justice Blackmun's opinion in Roe v. Wade, oftentimes when there are disputes about those kinds of matters, they are subjected to the adversarial truth-finding process of the trial. Different parties bring claims, they bring their experts to testify on these matters, but none of that happened. None of that happened in the Roe v. Wade case. And when the Supreme Court received the matter, there was no factual findings by the lower court. So everything that Justice Blackmun says in Roe v. Wade, in an opinion that was decided 7-2, 7 justices in the majority, 2 justices in dissent, everything Justice Blackmun says is his own assertion, untested by the adversarial truth-finding process of the lower courts, and that should be the beginning of our skepticism about what Justice Blackmun says in Roe, especially the factual assertions he makes about medicine, history, sociology, philosophy, and such like, none of which was tested by the adversarial truth-finding process and is suspect as a result. So the Supreme Court got the case, and in summary, what the court held in a 7-2 decision was that laws restricting abortion implicate an unenumerated, that is an unwritten, fundamental right to privacy that they believed was implicit, again, not stated explicitly, but implicit in the due process clause of the 14th Amendment. And the best way to understand Roe v. Wade is to try to unpack that holding. What is an unenumerated right? What does it mean for a right to be declared fundamental? What is the substance of the right to privacy? And what is the source of authority of this right according to the U.S. Supreme Court? And what you're going to find as we march through these 47 years of jurisprudence is that the right to abortion in American law has never really been on a firm foundation. It begins in the Texas trial court, rooted in the 9th Amendment. It moves to the 14th Amendment in Roe v. Wade itself. It's grounded in a right to privacy. That changes in 1992 to a liberty interest, as moving away from the norm of privacy to the norm of liberty. And then in subsequent decisions, especially in the dissents we see from justices like Justice Ginsburg, we see the norm shifting from liberty to the norm of equality. So in some ways, it's fair to say that the right to abortion in American jurisprudence has always been a kind of policy conclusion in search of a justifying rationale, a kind of casting around different sources of authority, different norms. It's never been on a firm footing, and that's one of the many reasons why the right to abortion has been so controversial, even among people who support abortion rights. So let's unpack what the fundamental holding of Roe versus Wade was. The court in Roe versus Wade used a method of constitutional interpretation known as substantive due process to reach its conclusion. Okay, so let's take a step back and remember what the court is doing, what it purports to be doing, and what its role is in our scheme of government here in the United States is to interpret the Constitution, to read the Constitution and to see what it entails and to measure what the Constitution requires against state action. And if there's a case in which the federal government or the state governments do something that contravenes the guarantees of the Constitution, then the court exercising judicial review will strike those laws down. But what if, in a case like this, there's no specific enumerated, that is written, protection in the law for an individual right? Sometimes the court will read into the Constitution a substantive right that's not written down, okay? And the doctrinal principle that the court applies in a case like that is called substantive due process. Why is it called substantive due process? First of all, because it purports to interpret the procedural guarantees in the 14th Amendment. There's also a nearly identical guarantee in the 5th Amendment. And the procedural guarantee that the court focuses on promises that no person shall be deprived of life, liberty, or property without due process of law. Now, on its face, what that guarantee promises is that when the state does deprive you of these things, before it deprives you of these things, or perhaps shortly after it deprives you of these goods of life, liberty, or property, you are entitled to some procedural safeguards. The state can't simply do it in an arbitrary and capricious way. It will do so pursuant to fair process, due process, okay? Now, on its face, that just looks like a procedural guarantee, a procedural safeguard. But what courts have done in Dred Scott, in a case called Lochner versus New York at the turn of the 20th century, and again in Roe v. Wade, purported to read into that procedural guarantee certain substantive protections. Certain protections, and they began in Roe v. Wade to focus on the protection of privacy. They say, well, there's a right to privacy that's implied by these procedural safeguards, a substantive right. Now, immediately you can see why the doctrine of due process is controversial, because pursuant to interpreting this procedural language, the court is bringing into the meaning of the Constitution and effectuating that meaning by striking down duly enacted laws by the federal and state government, pursuant to their interpretation of the substance, which is not written into the text itself. So it's an extra textual kind of importation of a good that the court brings in and then invalidates state action that they believe violates that good. So you can see immediately the problem, why substantive due process itself has always been highly controversial. Because the first question that obviously occurs to you is, how do judges, who are not supposed to be doing politics, who in our federal system are not elected, not accountable, by design, not accountable to the public, they in a sort of counter-majoritarian way, they are appointed by the federal branch and confirmed by the Senate, by the executive branch and confirmed by the Senate. These justices and judges in the federal courts, they themselves are insulated and not accountable to the people. And they're not, and one of the reasons for that is because they're not supposed to be doing politics. They're supposed to be fairly interpreting the meaning of the Constitution when they're doing constitutional interpretation, or of statutes when that's what they've been called on to do, okay? So the first thing that immediately presents itself as a concern when you consider a doctrine that allows justices and judges to read into the Constitution unenumerated, unspecified, unwritten rights, is how do they identify these rights? How do they identify the contours of these rights? Where do they come from? What analytic framework do they use to try to identify and apply these rights? And more deeply, doesn't it present a temptation for unelected, unpolitically accountable judges and justices to import their own policy preferences into the law in a basically unreviewable way in terms of the political branches, if you're talking about constitutional interpretation? Doesn't it tempt them to do politics and policy under the auspices of reading into the Constitution goods and rights that are not explicitly stated there? What are the limiting principles of this analytic approach? And how does the court preserve its legitimacy as a judicial branch by practicing substantive due process when it might open itself up to the claim, if it succumbs to the temptation to do politics and policy, to actually import these rights into the Constitution that simply aren't there? So where then does a right to privacy come from? The court in Roe says, well, there's a right to privacy that is implied by the 14th Amendment's procedural protections, procedural safeguards. Where does this right to privacy come from? Well, of course, the Constitution has provisions that protect the good of privacy. For example, the Fourth Amendment protects persons from unreasonable searches and seizures of their persons or their effects or their property. And that's obviously meant to safeguard the good of privacy, even though the word privacy isn't used. But where does the right to privacy come from that's so capacious that it embraces a right to abortion? Well, I mentioned the Griswold case a moment ago. In 1965, there was a case in which there was a law in Connecticut that forbade the use of contraception by married couples. And that was struck down in an opinion in 1965 under the auspices of its violating the right to privacy. And in that opinion, Justice Douglas cast around for a variety of sources of authority in the Constitution itself, the First Amendment, the Fourth and Fifth Amendments, the Ninth Amendment. He used metaphors of shadow and light. He talked about emanations and penumbras to try to discern or divine this right to privacy, which he discovered in the Constitution in his own interpretive mode, and then used that interpretation to strike down the state law of Connecticut. Well, the same right to privacy that was enunciated in that case is extended in the case of Roe v. Wade, which explains, by the way, why when judges and justices are nominated to the court, in their confirmation hearings, you frequently hear questions raised about Griswold versus Connecticut, because that was the analytic foundation of the right to privacy that was extended in Roe v. Wade. So what Justice Blackmun purported to do in Roe v. Wade was to look at prior cases that seemed to relate to the good of privacy. Loving versus Virginia, which related to marriage. Skinner versus Oklahoma, which related to procreation. It involved a law involving sterilization of prisoners. Griswold versus Connecticut, I've already mentioned. And then a couple other cases involving family relationships and the rearing of children. So Justice Blackmun said, well, we have a zone of privacy that we've recognized, that we've inferred from the procedural protections of the 14th Amendment. And they've involved things like marriage and family and procreation, obviously contraception, rearing of children, educating of children, family type goods, right? And he said, well, in light of that, the right to abortion, because it relates to the right to terminate a pregnancy, is in the same ambit as these other zones of privacy. And so the right to abortion must be situated under the umbrella of the right to privacy as well. Now I'm going to stop just one second and notice that one need not throw away all these other cases relating to privacy if one is concerned about Roe v. Wade. In fact, there are very famous commentators and even judges who identify themselves as liberal and progressive, who themselves favor as a political matter the right to abortion, who took the view that there is a right to privacy and there are zones of privacy, but abortion is not within that zone of privacy, because it obviously is distinguishable from those contexts because, first of all, it involves non-private interactions with doctors and techs and nurses and usually for-profit outpatient clinics, but also more deeply because it involves the termination of the life of a third living human being. And it is not solely a self-regarding or contained action, and therefore it is not properly understood as within the zone of privacy. So one could coherently affirm the goodness and the legitimacy of all the cases connected to zones of privacy and even substantive due process itself, and still say that Roe v. Wade runs afoul of all and is not rightly, is in fact an abuse of constitutional interpretation. So Court says it's an unenumerated right to privacy that extends to abortion, and this right to privacy, this right to abortion, is a fundamental right. And what the court, and the implication of it being a fundamental right, is that it enjoys the highest protection of the law in our constitutional framework. Once a right has been deemed to be fundamental, it's almost sacrosanct. States may not, except for the most compelling reasons, pursuant to the most narrowly tailored means, can states interfere with that right once it's been deemed to be fundamental. And the mechanism of that protection is a standard of review that the courts use to evaluate state action, known as strict scrutiny, where the states have the burden of showing that they're following a compelling interest. That's the highest justification that they can muster, and they're doing so pursuant to a narrowly tailored, that is the least restrictive means possible. And states almost always lose when they seek to abrogate or interfere with a right that the court has deemed fundamental. Now, by contrast, there are rights that are important. They're called protected liberty interests, is one way to describe them, which states can abrogate and limit, and do so all the time when they are pursuing a legitimate interest by virtue of means that are rationally related to that goal. Okay, and that's called a rational basis standard of review. So when the Supreme Court in Roe v. Wade declared the right to abortion to be fundamental, they were basically imbuing it with the strongest protective cover that any right in our constitutional framework can enjoy. In the words of one justice, strict scrutiny, which is the protection that the fundamental right enjoys, is strict in theory, it's fatal in fact. It means essentially that there are no limits on the exercise of that right. Now, one of the things that the court did not address in Roe v. Wade is who or what an unborn child is. You would think that that would be something that they would need to grapple with, since there is in some ways a zero-sum vital conflict between the mother and the unborn child that she carries. But the court purported not to pass judgment on that question. There is some language in the opinion about medical history and philosophy and sociology and so forth. And again, we should remind ourselves that none of that was tested by the adversarial process. It's entirely the musing of Justice Blackmun, untested by the truth-seeking functions that the evidentiary hearings at trials provide. But put that to the side. They say, we're not going to answer the question of who or what an unborn child is. People disagree strongly about that. However, the court said that the word person, as it's used in the 14th Amendment, the word person that says no person shall be deprived of life, liberty, or of property without due process of law, nor be deprived of the equal protection of the laws, the word person in that safeguard does not refer to the unborn child. It doesn't embrace or protect the unborn child. And Justice Blackmun even goes as far as to say that if it did, then the right to abortion could not stand, because the rights of the unborn child as an equal person would have to be considered and balanced in a full way against the rights of the mother who is seeking the abortion. The court got to this conclusion. The court drew the conclusion that the word person in the 14th Amendment did not apply to unborn children, really with a very cursory and truncated analysis. In fact, they simply said, if you look at the word person as it's used elsewhere in the Constitution, it's clear that in those other usages, it's not referring to unborn children either. And therefore, the usage of it in the 14th Amendment must likewise not apply to the unborn child. This is not a very sophisticated or searching mode of terminological inquiry of a constitutional term. It is very cursory. It really amounts to hand-waving, and it's another source of controversy surrounding Roe v. Wade. And I want to draw your attention to one other feature of Justice Blackmun's reasoning. Justice Blackmun says the 14th Amendment itself, which provides due process protections for persons in the United States, doesn't apply to unborn children, but it does include a fundamental right to abortion that states may not interfere with, except under circumstances that I'll articulate in a moment, which turn out not to be very meaningful, and it turned out to be an absolute victory for the abortion rights side, another reason why the case is controversial. But I want to just say one brief thing about the history here. Okay, we talk a lot about originalism, we talk about different ways of interpreting the Constitution, and many people, originalists, both on the left and the right, agree that you should read the terms of the Constitution in light of their original meaning, in light of the meaning as they were originally understood at the time of their adoption. Okay, otherwise, you can import whatever meaning you want to, and judges can make law and legislate from the bench under the auspices of constitutional interpretation. the original understanding, the history and tradition and the text itself have to tether the judge to the Constitution. Otherwise, judges can do whatever they want and they cease to be judges, despite the fact that they have all the trappings of judges, being politically unaccountable, being tenured for life, and so forth. So, but I'm not going to say a lot about this, but it's important to recognize the extreme creativity, let's put it that way, of Justice Blackmun in reading that into the 14th Amendment. The 14th Amendment was ratified in 1868. It was one of a handful of amendments that were adopted in the wake of the Civil War, trying to respond to the original sin of the American Republic of chattel slavery, trying to remediate in some ways and provide protections that were sorely lacking to folks who suffered in involuntary servitude unjustly, and to try to undo the harms of the wicked institution of slavery. Okay, these are rooted in an egalitarian spirit. They're rooted in the spirit of at least trying to make good on the wickedness of slavery in our nation's history. Okay, it was ratified in 1868. It is uncontroversial to suggest that no one in 1868 thought that the 14th Amendment meant that the states that were ratifying the 14th Amendment could not regulate or prohibit or ban abortion. Okay, in 1868, abortion was forbidden in most every jurisdiction in the United States, and shortly after 1868, a couple months after Ohio ratified the 14th Amendment, they criminalized abortion. They extended their criminalization of abortion to the moment of conception. And if you read the history of that, if you read the legislative history of that state law, the justification for the law, according to the Ohio legislature in 1868, was that abortion constituted child murder. Okay? So what that means is the Ohio legislature, which ratified the 14th Amendment, and then a few months later criminalized abortion from the moment of conception, had no sense at all that the amendment they had ratified was in any way in tension with their desire to forbid abortion from the moment of conception because it constituted homicide. Right? That gives you a very small sense of the historical original understanding of the 14th Amendment, and it leads you to conclude that, of course, as originally understood, the 14th Amendment at best has nothing to do with abortion, and was not in tension with efforts by the state legislatures to criminalize abortion or the common law criminalization of abortion in those jurisdictions that didn't codify that. Okay. So in order for Justice Blackmun to read into the 14th Amendment a right to abortion, he has to have a mode of constitutional interpretation that is disconnected from the history, text, and tradition of the Constitution itself. It means he is far untethered. He is simply reading into the Constitution a right that he thinks is important and that 6 other justices thought were important, but a right that had never been considered to be part of the 14th Amendment's protections. And so it is utterly novel. And so you would expect Justice Blackmun to come forward with a well-articulated dynamic theory of constitutional interpretation that says, I don't need to be tethered to the history and tradition of the Constitution. I can basically read into the Constitution whatever I believe is normatively sound and important. But and there are some scholars that have done that or have tried to do that, but Justice Blackmun doesn't do that in this case. He doesn't articulate a theory of constitutional interpretation that can bear the weight of what he's doing by changing every law in the country and stripping the authority of these states and federal government from extending any protections, really any protections at all, to the unborn child. Okay? So that's as a legal matter. The court says throughout its opinion, we're not going to say what a child is in the womb, but then throughout the rest of the opinion, they refer to potential life. They refer to potential life, and the core of the holding of Roe v. Wade is that the state may not impose its theory of life on private persons who may have a different view, right? And if you are declaring as a matter of law that the legal status of a segment of the human family is up to private ordering and subjective decision-making, you are declaring implicitly that that is not a person, because one of the hallmarks of being a legal person, being a moral person, being a person as a matter of basic justice, is that your worth and the protection of the law extends to you regardless of what other people think. It is an objective status. It's not simply a subjective status that every individual can decide for himself. So the court, despite its protestation that it's not resolving the moral question of who counts as part of the legal and moral community, it implicitly is clearly doing so by saying that the state may not extend protections to this segment of the living human family. And it ignores entirely the continuum of human life that we learned about yesterday from Nick Ostriaco, that the life of the living organism begins at conception, and it's the same organism throughout the various gestational stages, from conception through birth through the various stages of maturity as well. Okay? So the court implicitly says the state's interest in protecting unborn children is not very weighty. In fact, people should be able to decide for themselves about who and what the unborn child is as a legal matter. Okay? But on the other hand, the court says there are very significant interests of women who are seeking to get abortions because of the inarguable burdens of an unplanned or unwanted pregnancy. So it is, of course, clear that an unplanned, unwanted pregnancy imposes unique and significant burdens on the woman who carries that pregnancy. And Justice Blackmun focuses on those burdens and balances those burdens, those maternal burdens, against a very low bar, a very small interest that he marginalizes about the state's interest in the unborn child. The unborn child is subpersonal as a legal matter, and frankly, as a moral matter for the court in Roe. And so its interests are very small. The state's interests on its behalf are very small. But the maternal interests, the woman, of course, is a person recognized by Justice Blackmun, and her interests in alleviating the burdens of pregnancy are very significant. Okay, so clearly she wins in the balance of those two competing interests. But the really interesting thing about Justice Blackmun's opinion is that he doesn't simply focus on the burdens of unwanted pregnancy. In fact, he focuses on the burdens of unwanted parenthood, and not just the burdens to the woman, but the burdens to her family and to society. He lists all the different burdens. He, of course, talks about the physical and psychic burdens of pregnancy. But then he talks about distressful life and future of having an unwanted child. He talks about mental and physical health being taxed by childcare. He talks about the distress for all concerned, not just the woman, but all concerned for the associated with the unwanted child. And the problem of bringing a child into a family already unable psychologically and otherwise to care for it. All these are factors that the woman and her responsible physician necessarily will consider in consultation. That's a direct quote from the opinion. Okay, so the idea is that a woman's right to abortion is justified not just by virtue of the burdens of unwanted pregnancy, but the burdens of unwanted parenthood. Okay, and now an attentive listener will notice, well, gosh, why would the remedy for unwanted parenthood, the burdens of unwanted parenthood, be abortion? Why couldn't we find a less violent and intrusive way, a way that accommodates the interests of the unborn child and the state's interest in protecting the unborn child? Wouldn't there be other forms of support for the woman that the state could provide, or that we could provide as private citizens, that short of destroying the child in the womb? And I think the answer, of course, is yes, but Justice Blackmun doesn't consider that. But it is important for us to notice that he considers the burdens to the woman as an unwanted mother, not the pregnancy, but as a parent, and even her family, as important interests that are burdened by the baby, in utero and ex utero. Okay? And that becomes important when we have to ask, what does Justice Blackmun mean when he talks about the definition of health? We'll talk about that in a moment. Then the decision pivots to the famous trimester framework. Okay? You'll sometimes read columnists and even and journalists and even law professors say, oh, Roe v. Wade's the decision that legalized abortion in the first trimester of pregnancy. Well, that is, in some sense, literally true, but it is so woefully incomplete that it actually is deeply misleading and false, right? It is true that Roe legalized abortion in the first trimester. It also legalized abortion in the second and third trimester. Now, one other interesting thing about this is that no party in the Roe v. Wade case ever argued for this trimester framework. This is entirely an invention of Justice Blackmun and his colleagues, which gives further criticism to the opinion that what's happening in this case is the court is engaged in legislation. Because what they're saying is not just that there's a right to privacy implicit in the 14th Amendment, ratified in 1868, but it also extends to abortion, even though abortion was criminalized almost everywhere in and around 1868. But it also, the 14th Amendment Due Process Clause, implies a trimester framework of a shifting scale of the interest of the state and the mother that the state has to abide by. This strikes a lot of folks, and including in 1973, most notably John Hart Ely, who himself supported abortion rights as a political matter, as a crazy departure from the role of judicial interpretation, and was squarely situating itself in the world of legislation. Right? This looks like a statute. This doesn't look like an interpretation of the 14th Amendment, this looks like a statute. And what does the statute say? It says in the first trimester, the state may not interfere with the right to abortion. And it did so based on Justice Blackmun's assertion that early trimester pregnancies, first trimester pregnancies, are more dangerous than first trimester abortions, which is, by the way, an assertion that has been contested by Dr. Byron Calhoun, who has an interesting article in 2013 in the Lineker Quarterly, challenging the proposition that it's been demonstrated that abortion and the relative safety of abortion and pregnancy and carrying a child to term. I commend that to you. I'm not going to talk about that now, but one thing to underscore is that Justice Blackmun's assertion, scientific and medical epidemiological assertion, was not subject to the truth-finding adversarial process of the trial, and has never been demonstrated at trial. And yet you hear justices and commentators repeat that all the time, and it plays an essential role in Justice Blackmun saying no state may interfere with abortion in the first trimester of pregnancy. In the second trimester of pregnancy, he says the state may regulate abortion, but only for purposes of safeguarding a woman's health. Now that's different from the health exception, but it is only for the purposes of safeguarding a woman's health that abortion can be regulated in the second trimester. And then in the third trimester, the state may regulate abortion, but it must include exceptions for the woman's life or her health, which is not defined, although we may have some inkling about what he means when he articulates what he believes the burdens of unplanned pregnancy and unplanned parenthood are. The court doesn't even try to defend the moral rationale for the trimester framework. They don't try to defend the proposition that we might infer that they think that there's an evolving developmental moral status of the unborn child as she gets older and bigger. The idea that somehow the law should protect the child more the stronger she becomes, or maybe the court's thinking about the bodily dependence of the child on the mother. The less dependent the child becomes on the mother, the more protection of the law she's entitled to. But even a moment's reflection shows that either one of those rationales stands on its head our moral tradition to protect the weak and vulnerable. If both rationales trade in the proposition that the stronger you are and the more independent you are, the more legal protection you get, and the weaker you are, the more vulnerable you are, the more dependent you are, the less protection of the law you get. And as we all know, that is a kind of upside down, inverted and corruption of our view that the law should protect the weak and the vulnerable in virtue of their weakness and vulnerability. Okay, so we don't know what the court meant by health in Roe v. Wade, but there was a case that most people haven't heard of called Doe v. Bolton, decided on the very same day in 1973. And we don't need to focus on the picayune details of the Georgia statute that was challenged, but one of the things that was challenged is whether or not the law could require a doctor to exercise his or her best medical judgment in assessing different questions connected to the abortion. And that was challenged. But it was affirmed, and the court said, no, best medical judgment is not unduly vague. It's a standard that we can apply in an objective and in a predictable way. And so in the way of affirming that provision of requiring best medical judgment, the court had occasion to talk about what health means as one of the factors that best medical judgment entails. And the court says health is really any aspect of a woman's well-being, not just related to her physical and mental well-being, not just related to her well-being while she's pregnant, but also familial well-being, economic well-being, any aspect that relates to her flourishing could rightly be considered health. And the person who decides when her health interests are implicated sufficient to warrant an abortion is the abortion provider himself. It is not the state, it's the abortion provider, who we all know frequently has a vested financial interest in the woman obtaining an abortion and is usually hasn't ever met her before and is unaccountable. So the court says, and here's the quote from Doe v. Bolton, that medical judgment may be exercised in the light of all factors: physical, emotional, psychological, familial. And this is echoing the list of burdens that Justice Blackmun talked about relating to unwanted parenthood, not merely limited to unwanted pregnancy. All these factors may relate to health. So what we end up with is a definition of health that expands to any aspect of a woman's flourishing as determined by the abortion provider. And you don't need to be a legal genius to recognize that that health exception, which the court says has to apply to any restriction on abortion at any gestational stage, is so broad that it swallows the rule. And some commentators have referred to that as the abortionist's veto. That is, any restriction that the state imposes on abortion, even say in the ninth month of pregnancy, can be overridden where the abortion provider says, I believe some aspect of this woman's well-being will be served by getting this abortion. And in case you had any doubts about how it would play out in reality, all you need to do is to consider this quote, which is representative, by Dr. Warren Hern, who is a very famous abortion provider who pioneered controversial late-term abortion techniques. And he said in 1997 that he would certify that any pregnancy at all, regardless of how healthy the woman is a threat to her life and could cause grievous injury to her physical health. And if that's true, if Dr. Hern would certify that any pregnancy is a threat to a woman's health, that means that if a woman's pregnant, she can get an abortion under his assessment, and his assessment would be privileged by virtue of the health exception jurisprudence. So the reason people say, correctly, that Roe v. Wade, and taken with Doe v. Bolton, licenses abortion throughout 9 months of pregnancy is because the health exception is so broad, the health exception has to attach to any restriction on abortion, and it's so broad that any abortionist can cite any aspect of a woman's well-being to override the state's judgment of regulation of abortion at that state. And the statement of Warren Hern is a perfect example of how that plays out in reality. It's not merely speculative. So, from 1973 to 1992, Roe v. Wade's fundamental right to privacy extending to abortion was strictly enforced, and it led to the invalidation of almost every challenge to restrictions on abortion, including side constraints like informed consent, parental involvement, 24-hour waiting periods, things that are very, very minor restrictions on abortion that command the assent of 70, 80% of the voting population. They were all struck down. Now, in 1992, folks thought that the court was poised to overturn Roe because many justices had been appointed to the court that people speculated were opposed to Roe v. Wade, including Justices O'Connor, Kennedy, Souter, and Thomas. And in the late 1980s, famous Democrat Governor Bob Casey signed into law in the state of Pennsylvania what was called the Pennsylvania Abortion Control Act, which provided a host of restrictions on abortion: informed consent, 24-hour waiting period, parental consent with a bypass provision, spousal notification with a bypass provision, and some other provisions that had, many of which have been struck down by virtue of applying Roe v. Wade. And what happened in this case, to the chagrin of many of the pro-life, to many members of really all members of the pro-life movement, is a 3-judge plurality, in a 5-4 decision, a 3-judge plurality wrote an opinion together. It was Justice O'Connor, Souter, and Kennedy, affirming what they described as the core holding of Roe v. Wade. Now, they changed some formal aspects of the law of abortion, but it turns out because they maintained the health exception from Doe v. Bolton, the law functionally didn't really change very much. But it broke the hearts of pro-lifers that these 3 justices affirmed the core holding of Roe, and they made 3 arguments for why they were doing so. One was a substantive moral argument, and the argument shifted, as I said, from privacy to liberty. And this is mostly attributed to Justice Kennedy, who said that there's a liberty interest in abortion that extends to a woman's right to define her own concept of existence, meaning of the universe and the mystery of human life, and her destiny must be shaped to a large extent of her own conception of her spiritual imperatives and her place in society, and laws that seek to define when life begins and who is part of the moral and legal community transgress her freedom to define for herself who and what the unborn child is that she's carrying, and then have and prevent her from pursuing her destiny as she sees fit in the social and economic and personal life, in her in those aspects of her life. Okay, so we shift from privacy to liberty, and it's really a kind of expressive individualistic rationale, anthropology doing the work here. Justice Kennedy says you can't state, define for a woman who and what an unborn child is. So he is implicitly deciding, along with his colleagues on the bench, that the unborn child is subpersonal. The unborn child is not co-equal with other members of the human family. And the state may not act as though that child is a co-equal member of the human family. The second argument the court made, and this is important, is they invoked the doctrine of stare decisis, which is a prudential doctrine in common law systems that judges are asked, although it's not an inexorable command, judges are asked to consider what the practical effects of overturning a prior wrong precedent will be on the stability of society. They're encouraged to consider things like how workable is the prior precedent, how much reliance is built up on that precedent. And that really is most important for our consideration here, because the court said in this case that women have relied over time on the right to abortion to vindicate their equality, to vindicate their freedom to structure and configure their lives as they see fit, right? And so they say a lot of people have relied on the right to abortion, and it would be destabilizing to revoke that right now. Now, you should say, I mean, an attentive reader of constitutional law notices that was true in a very significant sense in Brown versus Board of Education. There were entire cultures in the South and elsewhere that were built on segregated public schools. And the court in Brown v. Board of Education, to its great credit, said, yes, you've relied on this for a very long time, and under our precedent of Plessy versus Ferguson, which said that the state can operate a system that is, quote, separate but equal. Of course, it wasn't separate but equal. It was radically unequal and gravely unjust towards persons of color. And the court in Brown versus Board of Education said, you know what, of course, there's been a lot of reliance built up on this, but it's simply wrong and unjust and not part of our constitutional tradition, text, or history to believe that separate but equal is a sustainable norm that the Constitution enshrines. And so they overturned that, and they destabilized whole regions of the country. And it was good that they did that, because it was unjust and wicked what the segregation laws did. And so you see immediately that stare decisis is not meant as a bulwark to prevent horribly unjust laws, even in those circumstances where people rely on them. But the court said stare decisis applies to Roe, and so we're going to affirm the core holding. And then the third justification is in some ways the most worrisome. I won't spend a lot of time on it. The court said our legitimacy as a co-equal branch of government depends on sustaining Roe v. Wade, sustaining this lawless, extra-constitutional, highly controversial decision that was the most controversial decision of the late 20th century. Our legitimacy depends on sustaining that, because if we overturned it, people would say we're just doing politics. Well, you can immediately see the flawed reasoning in that argument, because, of course, half of the country would believe that you're just doing politics when you sustain the lawless, controversial, extrajudicial decision of Roe v. Wade. Okay? The court did, however, soften its abortion rights rhetoric. Justice Kennedy thought that the states were not given sufficient latitude to regulate abortion in Roe. So he says, okay, the state does have a legitimate interest in regulating abortion from the outset of pregnancy. And so it adopted this pre versus post viability dichotomy that replaced the trimester framework. And the court said, before viability, the state may not unduly burden a woman's right to abortion. It doesn't really say why. It sort of uses tautological reasoning, saying, well, we're going to pick viability as the standard, which, by the way, is a function of lung capacity. It's a function of the baby's ability to survive outside the womb by virtue of its mature respiratory system. And the claim here is that the respiratory development, which is contingent upon access to technology, it's contingent upon all kinds of accidental conditions, is a good workable line to divide the line between when the state may not unduly burden a woman's right to abortion and may regulate abortion more vigorously after that fact. It doesn't really explain in a satisfying way why that is. It just kind of says, well, that's the point at which the state's interest is strong enough, and it uses some language about a woman's willingness to agree to the abortion if she's waited post viability to get the abortion. So before viability, there was no undue burden that the court would allow. The court, again, doesn't define what an undue burden it is. It uses a synonym of substantial obstacle. It says you can't unduly burden it, but what it seems to mean is that the state cannot interfere with the ultimate freedom of a woman to decide to get an abortion or not. But in the same breath, the court said the state can, however, impose structural mechanisms whereby it tries to persuade women to carry the child to term, where it can provide medical information or other information, normative information about the state's view of the moral status of the unborn child, alternatives to abortion, including adoption and other kind of social services that might be available. That these are okay. The state can do these things. They don't amount to an undue burden, even if those regulations don't have the incidental effect of making it more difficult. Even if those burdens have the incidental effect of making it more difficult to obtain the abortion. So all the challenge restrictions, except for spousal notification, were affirmed in the 5-4 decision. And the court says, after viability, the state can ban abortion so long as they include an exception for the health of the mother And then they didn't disturb the Doe v. Bolton capacious definition of health, which includes any aspect of a woman's well-being, and also doesn't and also designates the abortion provider as the arbiter of when her well-being warrants an abortion. So despite all the moving around of the deck chairs and the changing of the formal language, pre versus post-viability, it's not a fundamental right, it's a protected liberty interest. At the end of the day, the problem remained that with the health exception provided a yawning exception that would invalidate any restriction on abortion at all. And so Planned Parenthood versus Casey broke the heart of the pro-life movement. 8 years later, after almost 30 states banned partial birth abortion, intact dilation and extraction abortion, which is a grisly, highly controversial form of late-term abortion where the child is partially delivered. Even some parts of the child's body might be visible to the abortion provider before the child is killed, which sent shockwaves to the nation when it became clear that this was practiced in America and practiced on healthy babies and healthy mothers. Dr. Ron Fitzsimmons admitted that on national television. The former president of the National Abortion Federation admitted that on national television. States banned abortion, banned partial birth abortions. Pro-choice leaders like Daniel Patrick Moynihan supported these bans. Joe Biden back then supported the ban. Not at all clear now whether he still supports that ban. He's not spoken to the question. But in Stenberg versus Carhart in 2000, in a 5-4 decision, all of those laws were struck down by purporting to apply Planned Parenthood versus Casey because the laws were written, the court thought, in a kind of vague way that didn't put doctors on notice as to what was criminalized. But the real reason that they were struck down is because they all lacked a health exception. And they all lacked a health exception for two reasons. One, the state legislatures judged, and they were supported, by the way, by the American Medical Association in this judgment, that there was no health condition whatsoever that had ever been presented in an actual living patient that warranted this kind of grisly abortion procedure. You could always induce fetal demise, that is to say, you can always kill the child in utero before you partially deliver the child and mangle his or her body before you deliver the intact corpse of the child, right? That there was the AMA wrote a letter in 1997 to the US Congress saying this is bad medicine, it's unethical, and it has no role. However, the abortion rights advocates brought out their own experts who said we can imagine circumstances. There are hypothetical circumstances in which this might be the safest mode available to women. The other side, of course, said, including the AMA, said no, there are always safe alternatives for the woman to pursue an abortion at the same gestational stage without recourse to this grisly, brutal procedure of involving a partial delivery of a living unborn child. But nevertheless, in a 5-4 decision, the court struck it down because of the absence of this health exception. And even though there was substantial medical authority for the proposition that there was no need for a health exception. So courts, the states didn't include a health exception because they didn't think there was a medical reason to do so. But even more importantly, they thought the inclusion of a health exception, as formulated by Doe v. Bolton, would allow abortionists like Dr. Warren Hern or Dr. Leroy Carhart to perform these abortions anytime they thought some aspect of a woman's well-being it was advanced by that procedure, okay? And Justice Kennedy was livid. He felt betrayed. He thought Casey was supposed to be a moderate statesman-like compromise. Justice Scalia said, what do you expect, Justice Kennedy? That's not at all what the holding of Casey or the reasoning of Casey supports. This is exactly implied by the Casey decision. And Justice Kennedy was very angry and very upset. President Bush was elected shortly thereafter. Congress enacted a nearly identical ban on partial birth abortions. There are some distinguishing characteristics of it. It was immediately enjoined by the courts. There were full-blown evidentiary hearings at the trial level on the need for a health exception. The district court in the Southern District of New York found that there was no need for a health exception, but thought there had to be a health exception categorically because of the Stenberg case. But nevertheless, the court sustained, in a 5-4 decision, written by Justice Kennedy this time, sustained the federal law banning partial birth abortions, even though they lacked a health exception. The vagueness issue was easily dispensed with because the law clearly defined what was prohibited. And the absence of a health exception was also dispensed with because Justice Kennedy said that there's substantial medical authority for the proposition that this isn't needed, that a woman's health can always be protected by a different kind of abortion at the same gestational stage, you don't need to revert to the prohibited procedure. And in the context, but they didn't undo, they didn't overturn Stenberg versus Carhart. They didn't change the lower court's decision. They simply basically distinguished very similar laws and said this one's okay, even though that one was struck down. And Justice Kennedy, in his arguments, focused on informed consent, focused on the role that these kinds of bans might play in informing women about the nature of this procedure and to dissuade them from doing it. And he used typically florid and grandiloquent language that he's known for, and talked about the respect for human life finds ultimate expression in a mother's love for her child. That really upset Justice Ginsburg. She thought that was trading in patriarchal, outmoded language about the role of a woman. And in her dissent, she signaled the new ground for an abortion right, namely an explicit right a fundamental right rooted in equality. She said explicitly that abortion is required to allow women to participate fully in the economic and social life of the nation. So that was the law in Casey. Again, we don't really know what an undue burden is until after the US Supreme Court tells us that a particular restriction is or is not an undue burden. So it's an inductive analysis. We know that, or we think we know that a 24-hour waiting period, informed consent, parental involvement, the kinds of things that the court affirmed in Casey are not undue burdens, but we won't know something's not an undue burden as a pre-viability restriction until it takes the 2 years necessary to get up to the US Supreme Court, who makes those decisions as a kind of, in the words of Justice White, and I'm paraphrasing, a kind of abortion control board for the country. And again, returning back to the original understanding of the Constitution, it can't possibly be true that the 14th Amendment, ratified in 1868, established the Supreme Court as the abortion control board for the United States of America. You don't need to be pro-life to recognize what an extraordinary departure from the rule of law that Roe and Casey were. Okay, so not much happened between 92 and 2016. You may remember that in 2016, Texas adopted a suite of laws, including requirements that abortionists have admitting privileges within a certain geographic radius of where they perform abortions, and that they adhere to certain pretty strict surgical center requirements in order to be licensed as abortion clinics. And the court, despite the fact that the U.S. Court of Appeals for the Fifth Circuit held those laws to be constitutional under Casey, the U.S. Supreme Court, in a 5-3 decision, recall Justice Scalia had passed away, held that the new rule for abortion, at least as applied to laws that mean to restrict or to protect the health and safety of women, involves an even more open-ended analysis by the court. The court will now analyze the restriction, the safety protection for health and safety of women, according to its own judgment about the benefits of that pre-viability law, weighed against the burdens on a woman's authority to obtain an abortion. And you can immediately see the discretion of judges and justices is utterly untethered from any objective criteria when it's just an open-ended burden-benefit analysis. And if you know that the judge supports abortion rights as a political matter, it's not hard to predict how they're going to assess the burden-benefit analysis as they apply it, without deference to the state's judgment or any fact-finding about the law's purposes. So the court said, Justice Breyer and 4 of his colleagues, including Justice Kennedy, who, by the way, didn't actually say anything in his own voice in that opinion, said that they thought neither of the provisions at issue conferred any medical benefits sufficient to justify the burdens upon access that each imposed. They thought that there were no benefits for the admitting privileges, they thought at all, and they thought that the burdens of the admitting privileges, they believed that the closure of half of Texas's clinics was a function of failure to comply or inability to comply with admitting privileges. And then they further inferred, even though this was not presented with sufficient evidence at trial, they further inferred, and these are factual determinations, that because half the clinics would close by virtue of not being able to comply with the admitting privileges requirement, there would be fewer doctors, longer waiting times, and increased crowding. And they drew the same conclusions about surgical center provisions. They didn't recognize any benefits, and they inferred without a lot of evidence that there were significant burdens. And in fact, the Court of Appeals found that at trial, it was the factual argument about burdens were really based just on the speculative assertions of one expert about the capacity of the remaining clinics and the causation. But the court said, we think it's adequate support for the district court's finding, and therefore this burden versus benefits analysis is what we're going to hold on to. There was a 3-justice dissent with Thomas, Alito, and Chief Justice Roberts, in which Thomas and Alito both challenged the insufficiency of evidence presented at trial relating to the question of burden. There was very little evidence presented in the lower courts, and Justice Alito, to take just one example, was that the evidence in this case shows that if the only clinics in the state were those that would have remained open, roughly 95% of the women of reproductive age in Texas would live within 150 miles of an open facility. And there was no fleshed out evidence about the capacities of the remaining clinics that would be open after the fact. And so the thrust of the dissent by Alito and Thomas was that the state, or the plaintiffs, didn't bear their burden of proving that that these laws actually, first of all, caused the closures, and then second of all, that the state of affairs after the closures would be unsustainable for women seeking abortions. So after Hellerstadt, we have this new burden versus benefit calculus that's done by the court without really any deference to the state's purposes. And this led Justice Thomas to lament that this is basically this new framework, this kind of unbounded burden versus benefit analysis, is, in the words of Justice Thomas, a regrettable concession of defeat, an acknowledgement that we've passed the point where law, properly speaking, has any further application. It really is the case that if you can get 5 justices to make a judgment that the benefits of a particular law do not justify their burdens, as they see those benefits and burdens, which of course is informed by their judgment about what pro-life laws are for, then you win or you lose. And that's not really consistent with a commitment to the rule of law. That's really doing politics, okay? So what about the future, right? We have Hellerstadt. We actually have a case this term, will be an opinion announced very shortly, challenging a Louisiana law that is similar, though distinguishable from the Texas laws. And what we're looking at with the current composition of the court is we have 5 justices who, based on their publicly available written records, their commentary, their judicial decisions, it's impossible to imagine the Justices Thomas, Roberts, Alito, Gorsuch, and Kavanaugh believe that the 14th Amendment entails a right to abortion. That the 1868 provision, as originally understood, actually entails a right to an abortion. So substantively, there's no way, I'm speculating, I don't have any inside information, but based on all publicly available information, there's no way that they believe that. There's no way that they believe that there is a right to abortion written in invisible ink in the 14th Amendment of the Constitution. There are 4 justices, Breyer, Sotomayor, Kagan, and Ginsburg, who would not only reverse Casey, modify Casey, they would return Roe to its full strength as a fundamental right grounded in the equality of women. And they stand very strongly in favor of abortion rights as a policy matter, and they read their policy preferences into the 14th Amendment itself. So you would think that that the situation is ripe for the possibility of undoing some of this abortion jurisprudence that results in an effectively unlimited right to abortion throughout 9 months of pregnancy because of the capaciousness of the health definition in Doe v. Bolton, which extends to any aspect of a woman's well-being and is decided by the abortion provider himself. And moreover, the subpersonal status of the unborn child as asserted by the jurisprudence itself, right? You'd think that there might be some way with these 5 justices to undo, to roll back these precedents, perhaps to reverse them altogether, right? But here's where we come to the question of stare decisis, which I mentioned before, which is, by the way, why when these justices are being evaluated for confirmation by the Senate, they're always asked about stare decisis. They want to know if these justices who know that there's no right to abortion in the Constitution, if they would nevertheless reaffirm these precedents because it would be too destabilizing to reverse them because of reliance, or because they think that the rule of law demands it, because the precedents are still workable, there's been no evolution of law to undermine them, and so forth, right? So that's really the open question, and it remains to be seen. Will the 5 justices on the court who know that it was a corruption of our fundamental organizing document that creates our government, the Constitution, that creates the relationship among the various branches of government, both vertically and horizontally, and provides inalienable rights for persons in our country, whether or not they know that reading the right to abortion into that, under the consigning an entire segment of the living human family to subpersonal status, putting them outside and beyond the reach, effectively, of the protections of the law. They know that that's wrong. They know that that can't really be a faithful interpretation of the 14th Amendment. Will they have the courage? Will they have the courage of the justices in Brown versus Board of Education? Will they have the courage to say, you know what, there will be some disruption if we overturn Roe? Although if you overturn Roe, what happens is the law will revert to the political branches of the states and the federal government, and you'll probably end up with a patchwork of laws. You'll have New York and Illinois that authorize abortion for almost any reason. You'll have states like Ohio, which has a heartbeat law. You'll have states like Kentucky, Ohio, South Dakota that are highly protective of the unborn child. There'll be a patchwork of possibilities, but it won't be as an extreme one-size-fits-all deformity of the Constitution imposed on the rest of the country, with the barbaric results of writing out of the protection of the law and the common good a whole segment of the human family. Will these justices have the courage of the justices in Brown versus Board of Education to embrace radical equality and to either in an incremental way or in a more sweeping way? And it remains to be said, by the way, that if you look at the Supreme Court, these are the ages of the current justices of the Supreme Court. So this composition is not fixed. There will be retirements and folks leaving the court for various reasons in the very near future. And so the law will be in flux, right? Maybe in more flux, it's hard to say. But this is a kind of inflection point for the U.S. Supreme Court, both in terms of its current composition and the near term, when that composition is going to change even further. Which leads me to conclude with the following statement, okay? What do we do as people who care about the intrinsic equal dignity of every human being from conception to natural death? People who believe that everybody counts, no matter who they are, no matter what race they are, no matter how vulnerable they are, no matter if they're a man or a male or a female, no matter what their opinions are, no matter how dependent they are on other people, no matter if they suffer from a disability or not, no matter how other people view them. People who are committed to building a culture of life are committed to the proposition that everybody counts. Everybody counts, no matter who they are or where they are or how unpopular they are or how much people hate them for unjust reasons or even just reasons. Everybody's entitled to the basic protection of the law against lethal private violence. Okay, that's what we believe as people committed to building a culture of life. What do we do? What do we do now in the face of this grave injustice, the state of the law that I've just sketched out? I'll tell you what we do. We have to, in our words and our deeds, show that the pro-life movement cares more about women and their babies than the abortion rights movement does by embracing the goods of solidarity, hospitality, and inclusion. And that doesn't just include unborn children, and it doesn't stop when they're born. And it doesn't exclude their mothers. It includes their mothers. It doesn't exclude their families. It doesn't exclude women who have had abortions, or even people who provide abortions. We have to genuinely be committed to this notion of radical love and radical equality and hospitality, and embrace even those people who we think have done monstrous things or advocate for monstrous things. We have to love them and show them that we really do, not in a cynical or instrumental way. We have to soften their hearts by our words and our deeds, by embracing them and loving them. And we have to engage the debate vigorously, tirelessly, but always with charity and civility. So thank you for your attention this evening. I covered a lot of information. We're at the end of our time together. And I would like for you to join us again tomorrow night, where we're going to have a wonderful talk from Jess Keating here at the University of Notre Dame. We'll talk about the history of feminism. And then on Friday, we'll have an opportunity to hear from Father John Paul Kimes to situate the culture of life question and principles within a larger, more capacious sense of solidarity and integral human development and radical love for the other and neighbor, and to avoid what Pope Francis calls a throwaway culture. And I'm sorry that this went on for so long, but when you have 47 years of abortion jurisprudence to cover, it takes a long time to get through it. And I hope you found this useful. And if you have questions or comments, you should feel free to email me at osnead@nd.edu. I'm happy to answer your questions. And you can certainly ask questions of our subsequent speakers that relate to my talk and we'll find a way. And I'll moderate those panels, and we'll find a way to get your questions answered. So God bless you. Thank you for paying attention. Thanks to everybody who made this possible. Take care of yourselves and take care of each other. Good night.